government you ever seen. By the time it's all said and done, you will see who is as murderer. This is going to show that my son was adopted by a detective who formerly worked in this case.
What you just witnessed wasn't a standard opening statement. It was a declaration of war against the legal system. This is the trial of Ronnie O'Neal, a man who waived his right to an attorney to represent himself against charges of premeditated murder, arson, and aggravated child abuse. O'Neal isn't just pleading not guilty, he is claiming that the state of Florida and local law enforcement are the true mass murderers who fabricated an entire case to paint him as a menace to society. The legal trap O'Neal faces is the heavy burden of premeditation. The state is pursuing a conviction based on the theory that he had a premeditated design, meaning he had the time to reflect, plot, and plan the killings. Under these charges, the prosecution aims to prove he hunted his family for no reason, using the testimony of his own son as the nail in his coffin. If the jury believes the state's narrative of a calculated, vicious attack, O'Neal faces the ultimate penalty. But O'Neal is banking on a specific legal defense to shatter the state's case, the heat of passion doctrine. He argues that his actions were not planned, but were a spontaneous response triggered by pure instinct after his wife allegedly attacked him and his children. Even more explosive is his claim of systemic evidence tampering. He alleges that vital 9/11 calls have vanished and that his son, the star witness, was adopted by a detective who worked on the case, creating a massive conflict of interest and the potential for coaching that could make the testimony legally unreliable. In this video, we will break down the high-stakes legal mechanics of this trial. We'll analyze how a self-represented defendant attempts to prove self-defense in a capital case, the rules of evidence regarding witness coaching, and whether a heat-of-passion defense can actually overcome a charge of premeditated murder. Is O'Neal a victim of a corrupt administration, or is this a masterclass in legal desperation? Let's look at the law.
Evidence going to show we are under some of the most vicious, lying, fabricating, fictitious government you ever seen. By the time it's all said and done, you will see who is the mass murderer in Tampa Bay, state of Florida. You will know why what occurred on March 18, 2018 occurred. And the evidence is going to show.
Ronnie O'Neal isn't just arguing that he is innocent, he is launching a full-scale assault on the integrity of the Florida legal system. He is making one of the most dangerous claims a defendant can make, that the evidence against him wasn't just found, it was fabricated. He's telling the jury that the police realized their case was weak and decided to fix it to meet the law's toughest requirement. Let's look at the moment he tries to turn the prosecution's burden of proof into a weapon of mass corruption. Let me break this down because O'Neal is playing with legal fire here. In any criminal case, the burden of proof is the ultimate hurdle for the state. O'Neal is essentially arguing that the state's system for justice is actually a system of fraud designed to manufacture a menace to society. But here is the problem. O'Neal is ignoring the plateau of latent potential. In Atomic Habits, James Clear explains that we often overestimate the importance of one defining moment, like this shocking allegation, and underestimate the daily habits required to reach a result. Fed D under Federal Rule of Evidence 3-0-1, the party against whom a presumption is directed has the burden of producing evidence to rebut it. By alleging police misconduct, O'Neal is shifting a massive weight onto his own shoulders. He must now prove that tampering exists, or his entire defense becomes a 1% error that compounds into a total loss of credibility. If your strategy is based on vicious lying by the government, but you have no receipts, your defense isn't a roadmap. It is a flight path shifted 3.5 degrees that is going to land you hundreds of miles away from an acquittal. O'Neal's eventual verdict will be a lagging measure of his legal habits in this very moment.
That law enforcement tampered with evidence to meet their such high burden of proof. Because originally it wasn't enough. So we had to tamper with evidence. Since it was such evident already, but we still had to tamper with evidence. The is going to show my son did not see me murder his mom. The The evidence is going to show he did not see me shoot his mom. The evidence is going to show my son said many things that are not true. The evidence is going to show that I called 911 during Kenyatta Barron's 911 call. But all of a sudden, it ends up after I called Kenyatta, after Kenyatta Barron's call was made. Now I'm calling 911. But originally, I called 911.
Every criminal case has a heartbeat, and in this trial, that heartbeat is the 911 call log. Usually these records are the gold standard of evidence. They don't lie and they don't forget. But Ronnie O'Neal is about to tell this jury that the official timeline they've been shown is a total fabrication. He's claiming that he was the one who reached out for help first, and that the police shifted the clock to make him look like a predator. Pay close attention to this detail, because if O'Neal is right, the state's entire narrative is a house of cards. Let me break this down for you, because this is where O'Neal's legal strategy hits a massive wall. In the world of evidence, 911 logs are considered foundational evidence. Under Federal Rule of Evidence 901, the proponent must produce evidence sufficient to support a finding that the item is what they claim it is. For O'Neal to win this point, he has to prove the state's logs are fake. The problem: 911 records are generally admissible under the public records exception to hearsay FRE 803 Part 8 because they are kept in the regular course of business. This is what James Clear calls a 1% error in his book Atomic Habits. If a pilot shifts their heading by just 3.5 degrees, they land in a completely different city. By challenging the 911 logs, O'Neal is trying to shift the jury's flight path. He's hoping that if he can create just a tiny bit of doubt about who called first, the jury will start to see a setup everywhere. But here's the truth: your outcomes are a lagging measure of your habits. O'Neal's habit of relying on instinct and conspiracy rather than authenticated data is a dangerous system for a trial. If he can't prove the logs were tampered with, this assertion won't just fail, it will compound into a total loss of credibility with the jury.
One, without even knowing she called 911 during her call. The evidence is going to show that your representatives and law enforcement, local law enforcement, wanted to make it seem like I'm some kind of menace to society. And I ran after killing Kenyatta Barron, knowing that authority was on the way to kill my own children. I wonder why I would do something like that for no reason. And I'm standing here competent as can be, representing myself today. The evidence is going to show my son did not witness me viciously beat his mom to death. The evidence is going to show my neighbor, Khalil Brown, whom they are trying to keep out of this trial, witnessed me take 3 strikes. The evidence is going to show that law enforcement and this administration wanted to make me look like a menace to society. So they added several mini strikes on that video and audio that you just heard. And they added several statements that I did not say. Anything that I may have said, they exacerbated it and made me say it.
Ronnie O'Neal just dropped a bombshell that sounds like it belongs in a spy thriller. He is telling the jury that the prosecution didn't just submit evidence, they remixed it. He's claiming that law enforcement took his voice, edited it, and looped slurs consecutively to make him sound like, quote, a terrorist, end quote. This isn't just a bold claim, it's a direct attack on the integrity of the digital record. Pay close attention to this next clip, because O'Neal is attempting to dismantle the state's most visceral evidence with a single allegation of vicious lying. This is where the legal system provides a massive shield called the Rule of Under Federal Rule of Evidence 106. If a party introduces part of a recorded statement, the adverse party can require the introduction of any other part that in fairness ought to be considered at the same time. This rule is designed to prevent exactly what O'Neal is alleging, the strategic omission of context to create a false narrative. But here is the catch. To win this argument, O'Neill has to challenge the authentication of the evidence. Under Rule 901, the person offering the evidence must prove it is what they claim it is. O'Neill is making a 1% error here. In the book Atomic Habits, James Clear explains that a slight change in heading, like a pilot shifting a plane just 3.5 degrees, can land you hundreds of miles away from your destination. By alleging a conspiracy of digital tampering without producing a forensic expert to prove the files were altered, O'Neill is shifting his legal flight path into dangerous territory. He's trying to reach the 32-degree breakthrough where the jury finally believes the system is corrupt, but his habit of making inflammatory claims without evidence keeps him stuck in the valley of disappointment. Ultimately, the jury's verdict will be a lagging measure of his habits in this courtroom. If he repeats these excuses without proof, the results will compound into a total disaster for his defense.
Consecutively over and over like Allahu Akbar, which I may have said once or twice. But they wanted to make me seem like a terrorist, and so you hear it 8 or 9 times, and you hear me calling Kenyatta Barron a bitch and a whore. The evidence is going to show that I called my dad after calling 911. But that call is all of a sudden missing from the T-Mobile records that we have acquired from T-Mobile. The 911 call that I made to 911 and the 911 call that you just heard cannot be proven that it was made, because after I called for an investigation of those 911 calls, all of a sudden they become missing from all evidence. The evidence is going to show Kenyatta Barron supposedly made a 911 call, but you cannot find that on her call log, which we pulled from her actual phone. They say she made a call at 11:43. There's no 911 call at 11:43 on her call log. All of a sudden, after I called for an investigation of the original call, that's what the evidence is going to show. The evidence is going to show I look alone. I am backed by mighty God. The evidence is going to show I love my children. The evidence is going to prove to you this whole entire case has been tampered with and fabricated before it's all said and done. I can guarantee you that. Mark my words. Evidence is going to show that they say I said, "Come out here, son, and help me kill this bitch." But my neighbor, Khalil Brown, nor my neighbor, Mona Lisa Brothers Gray, or any of her children, Mia Thompson, or Gracie Diggs, or Mr. Gray, heard me say any of those things. In fact, the evidence is going to show that Khalil Brown heard me say she killed me twice and then nothing else. The CRA is going to show. For some of you who don't know what that is, that's the criminal report affidavit.
For the last 10 minutes, Ronnie O'Neill has been swinging wildly at conspiracies. But right now, he finally reaches for a real legal weapon. He's about to reference the CRA, the criminal report affidavit. This isn't just a random piece of paper. It's a sworn document authored by the lead detective on this very case. O'Neill is attempting to use the prosecution's own paperwork to prove they are hiding the truth from the jury. Pay close attention, because this is the first time he actually tries to impeach the state's story with their own words. What you just saw is a classic defense tactic called impeachment. Under Federal Rule of Evidence 613, a party can examine a witness about their prior statements. O'Neill is pointing to the CRA authored by lead detective Thomas Dirks to show a direct contradiction. He's telling the jury the detective's own sworn affidavit says I told neighbors to call 911. So why is that missing from the audio the state just played for you? In the book Atomic Habits, James Clear discusses the aggregation of marginal gains, the idea that a 1% improvement in everything you do leads to significant results. In a trial, every time you catch the state in a contradiction, you are gaining 1% more reasonable doubt. If O'Neill can prove the state's audio was strategically omitted to make him look like a menace, he shifts the trajectory of the entire trial. As Clear notes, a pilot shifting a plane's heading by just 3.5 degrees lands in a completely different city. O'Neill is trying to shift the jury's destination from guilty to self-defense by using the state's own habits of documentation against them. But remember, outcomes are a lagging measure of habits. If O'Neill's habit is just to talk about the CRA without successfully entering it into evidence, this marginal gain will evaporate, and he'll remain stuck in the valley of disappointment.
That the law enforcement lead detective Thomas Dirks is the author of. The evidence will show that in that CRA, I told the neighbor, don't come outside. Call 911 now. But you don't hear that on this audio for some reason. You hear all these other things that I did not say. That same CRA will have the statements of Khalil Brown saying that he saw me take 3 strikes with that shotgun and nothing else. The evidence is going to show that Mr. Harmon here says that big chunk missing out of her arm was a bird shot. It was not a bird shot. And whatever kind of...
Ronnie O'Neill is about to challenge the laws of physics. He is looking at crime scene photos of his own family's closet and asking a question that sounds logical on the surface but masks a desperate legal gamble. He's talking about missing pieces of human remains and phantom bullet holes. Pay close attention to this detail on paper. This seemed like an open and shut case, but O'Neill is trying to convince the jury that the prosecution had to fix the crime scene to make his aim look more lethal than it actually was. This is a textbook example of why forensic crime scene reconstruction is the backbone of a murder trial. The state isn't just trying to prove that O'Neill fired, they are using ballistics to prove his premeditated design, his specific intent to kill. Under Federal Rule of Evidence 702, the state brings in experts to analyze blood spatter and bullet trajectories to help the trier of fact understand the evidence. O'Neill, acting pro se, is trying to conduct his own reconstruction from the podium. He's making what James Clear calls a 1% error. In the book Atomic Habits, Clear explains that a pilot shifting a heading by just 3.5 degrees as they leave Los Angeles will land in Washington, D.C. instead of New York City. O'Neill is trying to shift the jury's flight paths by just a few degrees. If he can make them believe that bullet holes were added to the wall to manufacture evidence of aiming at her head, he changes the destination from premeditated murder to self-defense. But remember, your outcomes are a lagging measure of your habits. O'Neill's habit of alleging vicious lying without presenting a competing expert to authenticate these claims under Rule 901 means his defense is likely to stay stuck in the valley of disappointment.
If it was a slug shot or a bird shot, where's the missing pieces of her arm? The evidence is going to show you will not see any missing pieces of her arm in that closet where she was shot. You should see some evidence of shots, but there were several shots added to the wall to make it look like I aimed at her head. That's what the evidence is going to show. Remember, I told you the evidence will not show you that my son witnessed me beat his mom to death, nor did he witness me shoot his mom. In fact, he didn't witness much at all. And the evidence will show my son said my dad shot my mom. Is the correct statements, if he even said it. Because I can guarantee you, the evidence is going to show you we are under the most corrupt administration you've ever seen in your life. I guarantee you I wouldn't waste your time.
On paper, this seemed like an open and shut case. But when you look closer, the defendant is making moves that would make any real lawyer's skin crawl. Ronnie O'Neill is about to do something you are almost never supposed to do in front of a jury. He's going to talk about a plea deal. In his mind, he's proving his innocence. But in reality, he might have just accidentally opened a door that can never be closed. Pay close attention to this next detail because this is where the trial takes a very dark turn. Let me break this down for you because this is an absolute disaster. Most people think mentioning a plea deal shows you have nothing to hide, but the law sees it very differently. Under Federal Rule of Evidence 410 statements made during plea discussions that do not result in a guilty plea are generally inadmissible against the defendant. This rule exists to encourage open negotiations without the fear that those conversations will be used as a confession later. By bringing this up himself, O'Neill is committing what James Clear calls a 1% error. In the book Atomic Habits, Clear explains that if a pilot shifts their heading by just 3.5 degrees, they land in a completely different city. O'Neill thinks he's landing in Innocenceville, but he's actually flying his defense straight into the ground. When a pro se defendant mentions a plea deal, they often open the door for the prosecution to bring in details about those negotiations that the jury was never supposed to hear. Your outcomes are a lagging measure of your habits, and O'Neill's habit of ignoring legal procedure for the sake of vicious lying allegations is a system designed for failure. He's trying to melt the ice cube by screaming at it, but he hasn't even reached 32 degrees yet.
I would have already took a plea deal of some kind if I knew I did something like this, because most people don't even go to trial when they know they've killed somebody unjustly. The evidence is going to show you who the killers are. I'm pleading not guilty to the charges of premeditated murder, attempted murder, aggravated child abuse or battery, arson, resisting arrest without violence. And while I'm at that, the evidence is going to show that they tased me for no reason, but they tampered with that video because they didn't want you to know the truth. It might sound far-fetched, but I guarantee you we're going to see who the liars are before it's all said and done. Mark my words, because my family lives were taken when my daughter was done. This is what the evidence will show. When my daughter was born, me who gave the command, the final command to keep her alive when she was on life support. When she was born, 2 pounds, 2 ounces, couldn't breathe on her own. It was me who fought to keep her alive. But all of a sudden, I just want to take her life. I'm asserting justifiable homicide because I acted in self-defense and moved to protect myself and my children from Kenyatta Barron. I'm going to be showing with evidence several reasonable reasons to doubt the state's allegations against me. Evidence will show that the state cannot prove that I premeditatedly killed anyone because I didn't have any time to reflect or plot and plan as if everything happened suddenly and spontaneous.
Ronnie O'Neill just shifted his entire strategy from everyone is lying to I had no choice. He is throwing out 2 massive legal shields, self-defense and heat of passion. But can he actually prove his actions were a spontaneous reaction, or was this a calculated, cold-blooded plan? Pay close attention to this detail because this is where the prosecution's premeditated murder charge meets O'Neill's pure instinct defense head. Let me break this down for you. This is an absolute disaster of a legal maneuver if he can't back it up. In a capital murder trial, the state's burden is to prove premeditation, meaning the defendant had the time and mental space to reflect or plot the act. O'Neill is trying to convince the jury that the killings were a spontaneous reaction triggered by pure instinct, a legal defense known as heat of passion. But here is the catch: O'Neill is committing a 1% error. In the book Atomic Habits, James Clear notes that if a pilot shifts their heading by just 3.5 degrees, they will land in a completely different city. O'Neill is trying to shift the jury's flight path from a conviction for premeditated murder to an acquittal for self-defense by adjusting his intent by just a few degrees. By claiming he acted to protect himself from the victim, he is introducing evidence of the victim's character. Under Rule 404, this allows the prosecutor to fight back with their own evidence of the victim's peacefulness to rebut the claim. This is O'Neill's plateau of latent potential. He is hammering away at the prosecution's story, hoping for that 32-degree breakthrough where the ice of the state's case finally melts. However, outcomes are a lagging measure of habits. If his habit is to shout about vicious lying instead of presenting specific instances of conduct required under Rule 405, those small choices will compound into a toxic verdict.
I responded out of pure instinct and heat of passion, eliminating any kind of premeditated design. And let me just say, the evidence will show since the state plans to kill me, if they can say that I killed my family unjustly, they plan to premeditatedly kill me, so they cannot say or deny me the right to premeditatedly kill Kenyatta Barron if she killed my children. The evidence will show that Kenyatta Barron had several medications and drugs such as morphine in her system. The evidence will show she had a domestic history and was arrested for domestic violence that same year. She also was born premature, just like Trinivia.
Judge, I object at this point.
I'm going to sustain.
Ronnie O'Neal is desperately trying to paint a picture for the jury, but he keeps forgetting one thing. The courtroom isn't a theater for your life story. It's a forum for evidence. He's about to go off on a tangent about the victim's birth history, likely trying to evoke some kind of bizarre destiny or shared trauma with his daughter. But the judge is about to hit him with a reality check. Pay close attention to this moment because it's a masterclass in why broad arguments will get you shut down faster than you can finish a sentence. Let me break this down for you because O'Neal is hitting the plateau of latent potential in the worst way possible. He's hammering away at the state's case, but he is not hitting the right spot. Under Federal Rule of Evidence 401, evidence is only relevant if it has any tendency to make a fact of consequence more or less probable. Whether or not the victim was born premature has zero impact on whether O'Neal acted in self-defense on March 18, 2018. In the book Atomic Habits, James Clear explains that a pilot shifting a plane's heading by just 3.5 degrees lands in a completely different city. O'Neal is trying to shift the jury's focus, but by bringing up broad and irrelevant history, he's steering the defense straight into a mountain. This is a 1% error that compounds into a loss of the jury's attention. Your outcomes in court are a lagging measure of your habits. O'Neal's habit of using inflammatory rhetoric and vicious lying allegations instead of sticking to the elements of the crime is why he's stuck in the valley of disappointment. When the judge says the argument is too broad, she's telling him his system for defense is failing because he's focusing on a goal of shocking the jury rather than the system of admissible evidence.
Sustain the objection as to that particular argument regarding Miss Barron being born prematurely. All right? You may continue on, Mr. O'Neal.
I didn't even state the basis of his objection.
I've ruled, Mr. O'Neal, okay?
I understand, but I have to state the basis of my objections, right?
Well, that is correct, and I just assume what the objection is. So go ahead and state it for the record, Mr. Harmon.
Proper argument.
That's sustained.
The evidence will show that she threatened to kill me with a knife just a few weeks before the incident, and she was angry about my relationship with my other child's mom, and about the fact that we had to be cordial for our newborn son. And the evidence will show that they had been going back and forth and arguing on Facebook and by telephone that whole afternoon before the incident. The evidence will show that me and my son was at my mom's house while I was putting brakes on my aunt's car. Me and my son spent the whole day at my mom and dad's house working on the car. When we came back home, I never knew she was arguing with my child's mom, my other child's mom, the whole day. That's what the evidence will show. Evidence will show that my daughter was prematurely born. She was autistic. My son Ronnie was diagnosed at the age of 3 with developmental delay and had the history of SLD. The evidence will also show that he was present but does not remember accurately or consistently what happened for many reasons.
Imagine your own child is the only eyewitness to a tragedy, but their own mind is working against them. On March 18, 2018, Ronnie O'Neal's son survived a nightmare, but now his father is using that very trauma as a legal shield. O'Neal is asserting that because of developmental delays and post-traumatic stress, his son, the state's star witness, is legally unfit to tell the truth. But here is the question most people don't think to ask: at what point does a child's trauma become a get-out-of-jail-free card for the defendant? Pay close attention to this detail because it's a direct attack on the most vulnerable evidence in the room. Let me break this down for you. O'Neal is targeting the legal foundation of witness competency. Under Federal Rule of Evidence 601, every person is presumed competent to be a witness unless the rules say otherwise. In cases involving child witnesses or traumatic events, the court must often decide a preliminary question under Rule 104 to determine if the witness is actually qualified to testify. O'Neal is committing what author James Clear calls a 1% error. In the book Atomic Habits, Clear explains that a tiny shift in a pilot's heading just 3.5 degrees can land a plane hundreds of miles away from its intended destination. O'Neal is trying to shift the jury's flight path from the son saw his father commit these acts to the son's brain is too broken to remember correctly. He is hoping this small shift in perspective will compound into a total loss of the state's credibility. But here is the truth: O'Neal is stuck in the valley of disappointment. He expects his progress in discrediting his son to be linear, but outcomes are a lagging measure of habits. If his habit is simply shouting unreliable without presenting medical experts to rebut the son's competency, he is never going to cross the plateau of latent potential required to actually win this argument. He's trying to melt the ice cube by yelling at it, but the legal temperature hasn't even hit 32 degrees yet.
Making him unreliable when it comes to the actual facts. He also has been diagnosed with PTSD, as he should be, because this is a very traumatic thing that he went through. He also was diagnosed with major depression disorder, intermittent confusion, and delirium. The evidence is going to show, the evidence and testimony will show that Ronnie Blair, formerly known as Ronnie O'Neal IV, may have been coached on what to say by family members.
Objection to argument.
And or law
Hold on. I will overrule the objection.
Thank you, Your Honor.
Mr. O'Neal, again, jury, this is what both sides believe the evidence is going to show, all right? And again, you will be the ultimate determiner of what the facts are. You may proceed, Mr. O'Neal.
Thank you, Your Honor. And these are also actual facts that Mr. Harmon left out when he told you about the report of his former psychologist, when he told you that he was adopted by his family members, which didn't work out as well, and he had to be placed with another family, which is now the Blair family. In that same report, it talked about how he may have been coached by family members. The evidence is going to show that my son was adopted by a detective who formerly worked in this case.
On the 18th of March 2018, a horrific crime occurred, and now the sole survivor, Ronnie O'Neal's own son, is set to be the star witness against his father. But here is the part that sounds like it was ripped straight from a movie script: that boy was adopted by one of the lead detectives on the case. Pay close attention to this detail because O'Neal is about to use this relationship to allege a massive conflict of interest. He is claiming the state didn't just find a witness, they manufactured one through witness coaching. Let me break this down for you because this is an absolute disaster for the prosecution's optics. Under Federal Rule of Evidence 6-0-7, any party can attack a witness's credibility. By revealing that the boy now lives with Detective Blair, a man who worked the investigation, O'Neal is providing a legal basis to argue the testimony is tainted. In the book Atomic Habits, James Clear explains that a 1% error in direction, like a pilot shifting a plane's heading by just 3.5 degrees, can lead you to a completely different destination. O'Neal is trying to shift the jury's trajectory away from the facts and toward a narrative of government corruption. He's hammering at the plateau of latent potential, waiting for that 32-degree breakthrough where the jury decides the evidence is fabricated. But here is the catch: outcomes are a lagging measure of habits. If O'Neal's habit is just to scream vicious lying without showing the specific system of coaching, he will stay stuck in the valley of disappointment. He is focused on the goal of an acquittal, but he lacks the legal system to prove the detective actually broke the rules.
Whom he now lives with. And I don't have a problem with that because he needs care. But I do have a problem with Mr. Blair being involved in this case, being called as a witness, being the new father of my son, and now he's being called as a witness when he could possibly have been coached by his new father, who is law enforcement.
All right, and again, Mr. O'Neill, I'll rule the objection. Again, this is what Mr. O'Neill is asserting the facts will be. You may proceed.
Thank you, Your Honor. The evidence will show and prove that very vital evidence was definitely tampered with as a strategic omission to cover up the facts of this case, making much more of the evidence unreliable, as I know for a fact it was altered as well. The evidence is going to show that 911 call of Kenyatta Barron is not compatible with what Khalil Brown saw and heard outside of my home. The evidence is going to show, when it's all said and done, who put those excessive lacerations on Kenyatta Barron's face. I can guarantee you that. In this trial or the next one, I can guarantee you that. Because like I said, I look alone, but I'm backed by a mighty God. And ultimately, it will show that none of the state's witnesses can draw any conclusions, especially because they didn't see anything that refutes my self-defense claim and theory. Nor can the state do so beyond.
We are at the finish line of one of the most chaotic opening statements in Florida legal history. Ronnie O'Neill has spent nearly 30 minutes alleging government corruption, but now he is going for the jugular of the American justice system, the burden of proof. He is throwing down a gauntlet telling the jury that the state cannot and will not be able to prove he didn't act in self-defense. This is his final attempt to turn a series of wild allegations into a legal, get-out-of-jail-free card. Let's look at the moment he tries to make his 1% of doubt into a wall of protection. Let me break this down for you because O'Neill is playing a very high-stakes game with the most powerful standard in the law. In a capital case, the state has to prove every element of the crime beyond a reasonable doubt. But when a defendant like O'Neill raises an affirmative defense like self-defense, it shifts the roadmap. He is asserting that the evidence won't just be unreliable, but that it is fundamentally incapable of refuting his pure instinct to protect his children. As James Clear writes in Atomic Habits, if a pilot shifts a plane's heading by just 3.5 degrees, they land in a completely different city. O'Neill is trying to shift the jury's flight path from premeditated murder to justifiable homicide by creating that tiny margin of doubt. He's looking for that 32-degree breakthrough where the ice of the state's case finally melts and his narrative of vicious lying by the government takes over. But here's the problem. Outcomes are a lagging measure of your habits. O'Neill's habit throughout this opening has been to make massive claims without the system of evidence to back them up. He is focused on the goal of an acquittal, but he hasn't followed the system of authenticated proof required by the federal rules of evidence. If he can't bridge the valley of disappointment by moving from rhetoric to actual admissible evidence, this final assertion won't be a breakthrough, it will be the final step off a legal cliff.